Hello, and welcome back to Coin Lady channel. The other day, Kim Jong-Densler gave an interview to Bloomberg. Even worse, his inflated sense of self-importance was on full show. This guy is completely insane. And Stewart, chief legal officer for Ripple's, already had some thoughts on the matter. And he spoke up about the things that worry him the most. And it's ridiculous. Kim Jong-un has no remorse for the things he is speaking in public. Also, he is completely confident in his ability to get away with anything. And then there's also this, which is perhaps much more intriguing. In regards to the SEC's appeal and the Ripple litigation, it turns out that a prominent lawyer in the XRP community agrees with a former SEC lawyer. And I'll simply drop a hint right off the bat. It has nothing to do with Ripple or XRP in particular. There are other ramifications even there. But before I go any further, let me state unequivocally that I have zero expertise in either law or finance. Nothing I say or write should be taken as recommendations to purchase or sell any particular security. Just a hobbyist here that occasionally posts films to YouTube on various crypto-related topics. Okay, so there's a Coinpedia article titled Ripple Case Outcome that covers the first portion of what I want to discuss. Bill Morgan, an attorney, rebuts the hopes of SEC Chair Jens Lairs. Attorney John Deaton recently released a statement in which he strongly disagreed with comments made by Gary Gensler, the chair of the U.S. Securities and Exchange Commission, regarding the cryptocurrency field. Dean's answer came after Deaton criticized SEC Chair Gensler for various comments made during a public address, including Gensler's characterization of the cryptocurrency market as riddled with hucksters and non-compliance. According to Deaton, whenever Gensler cited a court, he was speaking of the United States Supreme Court. According to the Deacon's logic, this could mean that Ginsburg is implying that the SEC considers itself to be immune to the law. In the first place, there was this thing that lawyer Jeremy Hogan posted. Here's a snippet from Kim Jong-un's recent Ginza interview with Bloomberg. The crypto space is full of hucksters and non-complaints. This must be Gary Gensler's answer to the second question. Will the verdict or the court's reasoning sway your opinion once more? Probably not. This is a misleading paraphrase, but it accurately captures the essence of the situation. You can't make this stuff up, Attorney Hogan concludes in his piece. This is Kim Jong-un's regime stating, yeah, we're about the law, and they mean it literally. They don't give a hoot about what the law says. However, they do worry about the judges. The SEC, under this guy's leadership, has become a crucial and repulsive organization. What the? John Deaton, an attorney, saw this and responded, any court includes the Supreme Court, the supreme law of the land. Just watch his reaction to the question posed. Because of their innate haughtiness, some individuals believe they are immune to punishment. Let me give you all an example of a megalomaniac by introducing you to Gary Gensler. Exactly right. Then we had Stewart, and naturally all the writing has reverberated, with commentary from the chief legal officer as well. And this is why I think we're all just so used to it. If you're numb to it, it's because you're too accustomed to it. The chutzpah of the SEC head to make such a statement. What worries me the most, and what should worry you as well, is the astonishing admission of an unelected bureaucrat that he won't follow the decisions of the courts, which is stated explicitly in the complete video footage. Now, obviously, that is spot on, and so even though they are currently losing in court, because the SEC has gone far beyond what that they know, the powers that Congress has a lot, and they intentionally misinterpret existing law anywhere that could potentially benefit their egregious overreach as a government agency, it is still correct. Obviously, they are still engaged in all of those activities. In any case, the good news is that the courts are slapping them down, and it's just remarkable that despite all the losses, they're just going to keep racking up and they're just going to keep pushing and seeing what they can get away with anyhow. It's a losing approach, but as Attorney DT, instead of megalomania, sometimes when people like this just want to get their god like they can do it regardless. That's why he's plainly doing the same thing, even though it seems ludicrous to average people like you and me when we consider the results in the actual world, which don't even line up in their favor. Anil Hardner, a worker at Ripple, answered to Stewart the whole time, writing, "He sounds like a typical bureaucrat who has to carefully choose his words because simple honest answers would incriminate him." Also, in response to the interview, XRP community attorney Bill Morgan wrote, "Ginza is back to crypto security tokens about which he says there is nothing incompatible with those tokens and the securities laws, except that the tokens themselves are just not defined as securities in the Securities Act, no matter how much he wants it to be otherwise." And then there's this, which leads naturally into the next section of the legal matter at hand, which is why the SEC, from a strategic standpoint, is pursuing appeal in the SEC versus Ripple case. For what reason are they acting in this way? In a rare turn of events, both Attorney Morgan and a former SEC attorney came to the same conclusion as to the true cause of that. Therefore, I was intrigued. This is where the discussion begins, as it was reported yesterday that Nance and CEO Champions, or CZ for short, had sought the court to throw out the lawsuit. I'm assuming everyone here is aware that the SEC is going to come after Binance and Binance with all the might at its disposal. Binance is challenging the US government's claims that the exchange engaged in unlawful securities transactions and other misconduct. The CEO of Nance, CZ, and his cryptocurrency exchange have filed a combined motion with the SEC to have the complaint against them dismissed. Both Binance Holdings and Zayo argued that the SEC had exceeded its jurisdiction in the complaint filed against them on September 21 in the United States District Court for the District of Columbia. The Binance and Zayo legal team's 60-page petition said the SEC should have developed clear norms for the sector before filing litigation against the cryptocurrency exchange, and then exercised retroactive regulatory authority over the cryptocurrency industry. They then passed around a sheet that read as follows, with a few key passages underlined. There is no basis for the SEC's complaint in the present securities laws. The SEC misinterprets the securities laws by removing the word contract from the phrase investment contract in order to assert jurisdiction over the cryptocurrency business. With these fresh theories in hand, the SEC is actively seeking to retroactively impose liability for sales of crypto assets dating back to July 2017. Previously to when the SEC issued any public guidelines on cryptocurrencies. What, if anything, does that bring to mind? Much of what is stated here sounds like it could have been drafted by counsel for Ripple's in the SEC versus Ripple lawsuit. It's the same argument, or at least the same argument in broad strokes, resisting SEC overreach by misunderstanding the law and proposing fresh theories. Therefore, it appears to me that the SEC will continue to lose in this case. And now the odds are stacked heavily against them. However, this does not mean that you should give up the fight. They may not actually be able to stop you. So, attorney Jeremy Hogan supplied the excerpt you see before you. From the brief submitted yesterday by Bound Counsel, if you are unfamiliar with this, it will absolutely blow your mind. If FinCEN file suit and allege BUSD is a currency by Nance, she will have achieved the holy trifecta SMH, which of course stands for shaking my head. Did you know that in March, Nance sued the CFTC alleging that BUSD is a commodity? 3 months later, Nance sued the SEC alleging that BUSD is a security. Doesn't that seem ridiculous? But I think we're all clear now. This USD coin, for example, is not only a commodity but also a security and, maybe, a currency in the future. Someone on the ledger wrote back to Attorney Hogan, asking if it wasn't true that US dollars may be any of those things, depending on their application and distribution. What did lawyer Hogan say in response? Perhaps so. Not necessarily. The trouble is that nobody knows for sure. Insufficient clarity, pals. Just thinking about it makes me long for the beginning, for the simpler times. This is the sort of thing we were discussing way back when, right? The SEC versus Ripple litigation. This is what lawyer Bill Morgan has to say about it. And he read aloud a section of the motion concerning the financial situation, which goes as follows. In other words, when underlying assets are sold on exchanges in blind bid or ask transactions, the SEC is wrongly claiming that its regulatory jurisdiction sweeps in the assets themselves, like the oranges and Howie. This is the same damn thing. The oranges are securities, the words "I'm doing the law stuff," which Judge Torres bitched Mac the SEC over and whacked him on down like not at all batch as they are. It was a treat to behold, but it's gonna happen again here. Alright, you moron. So, here we have an excerpt from the finance motion claiming that Attorney Morgan is correct in saying that the SEC has tried to include in its jurisdiction any sales of tokens it identified as securities, even when sold on exchanges in blind bid or ask transactions. That's why it's trying to get an appeal of the Torres ruling expeditiously. Naturally, he elaborates on that now. So, have a look at this. He also added, "There's another passage here. I'm going to make it full screen. I'm not going to read this, but if you want, you can pause right here and check this out." After that, Attorney Morgan composed an excerpt on the Ripple case. Then, in a fit of hysteria, he bolts outside, where he promptly spots the BAM defendants, for whatever acronym I have long since forgotten. But we have BAM Binance's side. Now, back in the States, the BAM defendants want to cite Judge Torres's decision in that case, which dealt with blind/bid trades on secondary markets. What if this court, upon consideration of this motion, either affirms or rejects Judge Torres's ruling on automated sales? As you may recall from the SEC versus Ripple case, Judge Torres ruled that blind bid ask transactions, all that on secondary markets, would typically apply for transactions for me, and Judge Torres ruled that of course, such transactions do not constitute illegal securities transactions. And naturally, a different section of her decision, which I think started on page 15. July 13th will forever be known as Victory Day in XRP. She made the claim that XRP is not a security. Therefore, there are two distinct parts, one dealing with extra pizzelles not related to security, and another addressing illegitimate programmatic purchases. The relevant question here is what will happen if the judge in the Binance case reaches the same conclusion. That if, there's simply completely opaque bidding and asking processes? So, how exactly does that make Howie happy? Test? In other words, now we're coming down to brass tacks. So, have a look at this. In a subsequent post, Attorney Morgan elaborates on this point, asking, is this why the SEC had to seek an interlocutory appeal of the Torres decision? It saw that Binance would use it. Binance Incorporated, et al., as co-defendants in SEC versus also, other markets and vendors often employ blind bid sales. To sum up, does everyone grasp his point now? Right? That much is obvious. Because of the anonymous nature of these trades, the exchanges find themselves in the same predicament as Ripple and fail the Howey test. This would hurt their second case if the case against the Ripples is resolved without an appeal. Is he suggesting that this is the same reason that appeals are being sought, as he claims? For the reason that the judge's attitude toward this ruling is negative. In other situations, you can assume that Coinbase would be in the same position as Biden. And here you have former SEC attorney Mark Fagel responding to Attorney Morgan and agreeing, so the answer seems to be yes, or at least it's agreed upon. That's why they filed an appeal, he confirms. If only Ripple and similar security token issuers were a problem, the SEC might be able to find a way to work around the issue. However, I could understand why they would try to appeal, given the ruling could derail their larger initiative against cryptocurrency exchanges. Oh, I guess I missed that one. That settles it. That settles it. Therefore, it is perfectly believable. Because it's unclear what, if anything, they'd intend to accomplish by filing an appeal during this interim period. First of all, it's not like this would deter them if they already know the odds of it happening are practically none. The standard procedure for filing an appeal is to wait until the case has concluded. An interlocutory appeal is up next. That's a quickie, for sure. Whether or not to proceed with one of those requires a separate set of factors to be considered, so it's a little bit different, but the appeal would still be an appeal if accepted. However, ordinarily you would wait until the case was closed. They realize that everything is disintegrating after all the time, effort, and money they've put into preparing and the case to get to this point. Their entire strategy is based on flimsy foundations. I'm not a financial counselor, so take what I say with a grain of salt. I'm not telling you to purchase or sell anything. Please like and subscribe my channel. See you later, bye.